All right. So today we're going to be talking about business practices and ethics. And, the interesting thing about this particular module is that this is not something that is like written in stone, like when we deal with legal issues and we can talk specifically about, regulations and policies and practices and legislation. um, you know, Business practices and ethics are often very nuanced in how they work, and there's situations that people have that are often very different. But just as a review, for our CPC, we've already gone through the two legal modules, and last week you went through recruitment and selection. Today, we're going to go through business practices and ethics, and then you've got one more module after that. You have the option and opportunity to also participate tomorrow in our sales day. If you've got other people in your company that want to just do that one module, I think that that's one that is of interest to people, even if they're not pursuing their CPC. And so today we're going to be referring to the ACSESS webpage, and we're going to learn about the ACSESS Code of Ethics, what it says, and we're also going to try to identify through some case studies or examples some ethical and maybe some unethical business practices with respect to candidates, customers, and consultants and recruiting. We're going to try to understand the legal ramifications and business ramifications of the decisions that we make from day to day with respect to ethics. And we're going to explain the process also toward the end of what we do when we encounter an ethical issue and what role ACSESS can play in helping with that. And then, of course, through all of this, we're going to be pursuing our CPC, and as members, we're going to commit to uphold all of the code of ethics and standards in the industry association. So first off, let's just kind of look from a real high level at the ACSESS mission statement: to promote the interest and growth of the Canadian recruitment and staffing industry. In order to accomplish this, ACSESS will identify, communicate, and monitor industry standards and ethical business practice. So very often, even if there's a law case or there's a civil litigation of some sort or contract law, they're going to contact often a member, a senior person from the industry who will refer to the ACSESS Code of Ethics about what some of those industry standards are. ACSESS's role is to positively influence and protect the regulatory and business environment. So we talked about that in previous sessions, to promote the credibility and visibility of the industry to all of the stakeholders, our audiences, the business community, the government, and our candidates and the general public. And ACSESS also is set out to provide member companies with strategic support services like the CPC and the conference and other tools to help them to conduct their business in an ethical and professional business manner. So first off, just understanding what ethics means, a moral philosophy. It's literally a branch of studied philosophy at universities and colleges, which seeks to address questions about morality, about concepts such as good and bad, right and wrong, justice and virtue, two different things. And we often talk about ethical behavior in different ways. So when we talk about a competitor or a customer or a candidate or a business practice or some suppliers, we talk about their honesty, and sometimes we think about their empathy, about their concern for others. We use words like integrity. I remember one time I had a business partner who, in my opinion, I thought was the most ruthless, I mean, toughest, edgiest business person ever, willing to go to the mat to negotiate everything to the nth degree. But at the end of the day, I always said, man, that person is fair. They never took advantage of their position. They never went too far beyond. And even if you disagreed and said, hey, I interpreted it this way, and they went, oh, geez, that's not what I think it meant. I thought it meant that. And then they say, I think it's only fair that I respect what you thought it was. Which I always thought was an interesting thing. Here's a person who's so committed to win battle, except for when it's unfair, and always willing to take the fair position instead of the winning position. And of course, if everything was fair, he wanted to win first. Accountability, leadership. I give these seminars on inspirational leadership, and really what it's all about. It's about how we treat people, about respect, about promise making and promise keeping. Our ethics are often about loyalty, being loyal to your employer, being loyal to your coworker, being loyal to your customer, to your friend, to your family. These are all examples of ethics. We don't always use the word ethics or ethical. We use words like loyal. Of course, there's law abiding. So there's people who are concerned about following the law. There's people who's concerned about getting caught for breaking law. So getting caught for breaking law isn't necessarily ethical. It's fearful, maybe respectful, but having some understanding of the intent and purpose of what the law is all about is ethical. Being focused on doing what you say, saying what you do, and truthful are all examples of ethics. 90% of the ethical problems we face, we really know what the right answer is. We know what we should do. The real question of ethics is not, did we know the right answer? The question is, when we knew the right answer, the thing that we should do, were we willing to do it? And that's an example of ethics. It's not unethical to have a misunderstanding and make a mistake and do something without an intent. But when we know what we should be doing, that's part of ethics. So the ACSESS, in order to become a member of ACSESS, a member company makes a commitment to follow the ACSESS Code of Ethics and Standards. And so in the Code of Ethics, it says, as members of the association, the company, we commit to uphold the Code of Ethics and Standards and to display it prominently in our place of business. We support the principles set forth below and acknowledge that compliance with these principles is in the best interest of the company, the ACSESS member companies, their candidates, employees, client organizations, and the reputation of the industry itself. Mm-hmm. So nowadays, particularly with virtual businesses and work from home, it becomes increasingly more difficult for ACSESS members to become demonstrative in letting the world know, their customers and their candidates and everyone know that they are members of ACSESS. So I encourage you to think about that. Is it on your website? Is your CPC going to be on 3 letters behind your name on your business card? Do you promote it in a positive way? So ethical behavior is the responsibility of everyone involved. And so, we ask this rhetorical question: is it the recruiter, customer, candidate, employee? Is it the recruiter, customer, employee in the industry? I mean, really, at the end of the day, everyone who participates in business has got a responsibility to know, understand, and uphold ethical behavior. So let's take a look at the ACSESS principles. Principle number 1, we will observe the highest principles of integrity, professionalism, and fair practice in dealing with our clients, candidates, employees, and all regulatory authorities, and with respect to confidentiality of records in accordance with the law and good business. So the first principle is this overarching high-level principle that says we're going to observe the highest standards when we're dealing with everybody on everything. So what are some good ethics in recruiting? So maintaining promises of confidentiality. Maintaining promises of confidentiality. We talked in our legal modules about what some of the laws were about confidentiality, but Ethics goes beyond the written law in terms of what people could reasonably expect from us in terms of confidentiality. Always seeking authorization for disclosure. This is part of confidentiality. So when a candidate makes a representation to you with your resume, for their resume, for example, getting authorization from them to present it to a potential employer is ethical business practice, and it's a good business practice. Knowing and complying with all legislation and regulations, that's obvious. Honoring contractual terms. So you remember when we talked about in legal, we talked about the different types of law, about common law, about statute law, and contractual law. And of course, the Supreme Court of Canada and our constitutional law. But contractual law is a promise written and designed with definitions on how we will treat each other. And so a violation of a contractual term is considered to be unethical. Equality, fairness, equity, and respect. We talked about these in terms of the law, but also in terms of the benefits to our companies, honesty and accuracy in our interactions. And so very often one of the examples of accuracy could be when you know something about a candidate and you don't necessarily disclose all that known information to your customer. So you've got a conundrum. You need to have permission from the candidate to disclose the information. You've got an obligation to the customer when you present a candidate to present all of the information that you know and not to withhold information. So finding the right balance of authorizations and disclosure is important. Some examples might be neglecting to perform a reference, but telling a customer that you did. Or even worse, falsifying a reference would be an issue. Misclassification of a worker as an independent contractor when you know that they ought to be classified as an employee would be a breach of ethics and therefore avoiding your obligations as an employer. And when you do that and a person doesn't get access to their unemployment insurance or to their employment insurance or to their Canada pension plan, these are all things that happen when we think we're just making a decision, a business decision. Oh, we'll treat them as independent contractors. The ramifications of our decisions go far beyond that. Direct recruiting a candidate who was previously placed. Ooh, this is a bad one. And this is something that should be covered in all of our customer contracts, that we won't solicit or recruit candidates that we've previously placed into a job. Of course, honesty is important. And so when we've got a temporary worker who doesn't show up for work, making up stories to cover for them is certainly an example of an unethical behavior. This is the interesting one. Contacting a candidate's current or former employer for a reference without permission. So think about the implications of that, right? You've got a candidate who's applied for a job with you. They're currently employed someplace. They're not sure whether they're going to get that promotion at the end of the month. And they're thinking, if I don't get the promotion this time, maybe I should move on. But I don't know. And even if I did move on, I'd have to talk to my husband or my wife and think about the implications of that. And where's my company going? And they've got all these things going through their head. Then all of a sudden, somebody phones their employer and says, hey, Steve's applied for a job with us, and we wondered if you could tell us a little bit about Steve. And then all of a sudden, Steve loses their job, or Steve doesn't get the promotion that they were really going to get. So having the implications of doing reference checks without authorization can be huge. And, sometimes people think, oh, I'll just make that confidential call to the previous employer from 2 jobs ago and ask them some questions. And how do you know? How do you know that that's not a sub-supplier, a contact, a customer of the place they're working right now? How do you know? So having permission is always the most ethical thing to do. Your customer spends a fair chunk of money with you every year, $800,000 in temporary staffing. And they indirectly hint that you restrict accepting candidates on a discriminatory basis. So they tell you, we don't want candidates of this race, creed, color, place of origin, race, religion, family status. Come right out and say it, but there's some implications there. So what do we do? It's a big customer. Do we take the details and emphasize that you'll work hard in providing the best candidates possible? Do you ensure that you get a detailed request in writing so that you can cast the blame on them when things go wrong? Somebody else, say, well, not my problem, my boss or a more senior person discriminate on behalf of us. They're probably better at it or have got more authority to do it. Do you go along with it and discriminate? Read that one. Go along with it if the discrimination does not relate specifically to a legally prohibited ground, physical attractiveness. So it's not a violation of the law, but it's a violation of our moral standards. So the answer is we take the details and emphasize that we'll work hard to provide the best candidates possible based on the required skills while adhering to non-discriminatory practices. So an answer might sound something like this. I think you probably have got something. Sorry, what's someone ask a question?
I have a question.
I
So
think,
what's the right answer in this situation? Would it be A or would it be D?
yeah, the answer is A. The answer is only A.
Mhm.
B says that the only thing that's stopping you is getting in trouble. And so we do things because they're right. We don't do things just because we're going to get in trouble. So the answer is only A. And an example of how that might work is this. We might say, Navneet, I think you've probably got it seems like you've got some pretty strong ideas about some of the characteristics of an individual who will best perform. And maybe what you really want is someone who's dedicated or hardworking or able to work long hours or strong enough to be able to lift 45 pounds. There are a number of things that we should be assessing for, and I want you to be assured that we will assess the candidate on the qualifications that you're looking for. And if they happen to be of a particular race or gender or whatever, we're not going to miss them. We're not going to overlook them because we want you to get the best candidate for them. And so, they might say, no, you can't send me this kind of person, in which case you have to say, I can't do that. Like, I really can't do that. And then that's when I say, obviously, that's why I always say you go back again and say, obviously, you've got a reason for saying that. There must be some bona fide characteristics that are very important for you in your selection. In the absence of those prohibited grounds, in the absence of race, in the absence of language or color or whatever gender or family stuff, in the absence of that, let's talk about the characteristics that are important to you. Let's talk about the qualifications that are important to you, because I'm certain that when we look at the entire pool of our candidates, we can find you the most qualified person. Again, giving them a chance to take it back, to move away from their discrimination. And I'm going to be honest, this is my opinion now. This is not, but I think that some people falsely come to the conclusion that people from a particular group all possess or are likely to possess many of the same characteristics. And so they might say, oh, nurses from this culture are more caring, or people from this culture are smarter, doctors from this culture are smarter, or something like that, which clearly is not true. Certainly not true on a candidate by candidate basis. And so sometimes I find as a business person, the way to get around I don't mean get around, to deal with um, a request for a qualification that is presented to you in a discriminatory fashion is to drill down to what that person's idea of the qualification or the skill it is that they want, in the absence of what culture or language or color or religion or whatever it is that people might have. Um, and and I think that it's been I can tell you in 40 years of being in the business, tens of thousands of jobs by my companies filled every year, billions of dollars in revenue. I've had two that I know of time where I had to fire a customer. That when they attempted to provide a discriminatory order, I'm not saying there wasn't only two attempts to provide a discriminatory order, there was hundreds of those. But when we presented it in a way where we said we were only going to focus on our skills, requirements, and traits of the individual in the absence of prohibited grounds, let's drill into what it is that you really want in terms of skills and experience, knowledge and behaviors. That only twice did I have to say to a customer, I'm sorry, I can't do business with you. So um, the fear of confronting a client, this example of the $800,000 temporary staffing contract, of confronting a client when they hint towards some discriminatory basis for selection, is overstated, because I think that very often customers don't realize the inappropriateness and the ineffectiveness, the lack of efficacy in restricting your search to particular groups. Okay, principle number 2. We will provide leadership in the adherence of both the spirit and letter of all applicable human rights, employment laws, and regulations. So this one talks, as I talked to you earlier, it's not just about law. It's also about what the spirit of the law is. What is the intent and purpose? And so sometimes, if you're saying, oh, how do we, if we look at this semicolon or this word or and, we can interpret this differently, and then now we can do a bad thing because it's legal, because of where the semicolon is. Changes the meaning of the sentence. This is not ethical behavior. The principle is that we look at the spirit and intent along with the letter of the law in the way that we apply our decisions and our business practices. So discrimination in recruiting, and we've talked about this in our legal practices: age, creed, disability, family, marital status, gender identity and gender expression, race. We talk very often, they list them out: color, ancestry, place of origin, creed, ethnic origin, citizenship. So I often refer to as race and related grounds. The receipt of public assistance. Has a person ever received welfare? Did they get let off the hook on something? Did they get subsidized housing? Did they get school tuition assistance? None of these are grounds for selecting a person. We talked in our legal thing about record of offenses and what it means to whether or not that person has been pardoned from their offense or not. We talked about a person's sex, including other aspects of sex like pregnancy or gender identity and sexual orientation. These are all areas that we just don't need to go. Like there's no benefit to it. It doesn't, there's no assistance to it. There's only limiting our pool to a smaller group of candidates through unethical or illegal standards only undermines our ability to be a great company. and a great service provider. A client requests that we recruit millennials for a role. The company is a startup and they want young, dynamic people to work with them. Well, again, the expression is dynamic. We want outgoing, dynamic, hardworking, highly communicative, energetic people. And they come in all ages, races, creeds, colors, religions, places of origin, sex, sexual orientations, not just millennials. A client indirectly hints that the recruiter only present female candidates for a front reception role. Again, discrimination. A client has a role for a forklift driver. They must have their license and be able to lift 15 pounds. Okay, that's fine. Got to be licensed to drive that fork truck, bona fide occupational requirement. 15 pounds, I think in most provinces, the number is 45. You know, that a person, you can't ask a person to lift more than 45 pounds, but you can say you got to be able to lift 15. And clearly some people can't lift 15. Bona fide occupational requirement. They request to have Brian back. Brian's been here before. No problem. Bona fide occupational requirement. A person with skills and experience and knowledge of the job with less training requirements and is proven to integrate well into the group, asking for a person back again. No problem, not discriminatory. And if Brian's not available, then to recruit another Brian, male, for this role. So everything was fine. Right up until they said, and if not, let's get somebody just like Brian who happens to be a male. If they said, let's get somebody just like Brian, no problem, because that implies that a whole bunch of the bona fide traits that Brian has that we could recruit for, but certainly not gender. Principle number 3, we will take all reasonable steps to provide clients with accurate information on our candidates. And we'll only present candidates that have given us authorization to represent their application for employment. So we talked about that. So doing a great matching job and being honest to your customer about the stuff that you find out, maybe not overstating or misstating the qualifications of a candidate in order to get them started or to get a job offer. So here, this is an interesting case. This is a treaty group. And the reason why I don't mind talking about this particular case is because I was personally hired by the staffing company to be an expert to write a report for them when they were being sued by the treaty group. So, and by the way, they didn't use my report. They didn't use my report because my report basically said, well, you might have done a few things wrong here. Here's some of the standards that you should have applied to. Here's some of the standards in the industry. They didn't like that. So first off, I'm not sure the company did all the right things, but they made some mistakes. Secondly, I didn't particularly, not for personal reasons, think it was the most ethical thing to get an expert report to understand what all the industry standards were. And then once they found out that they hadn't adhered to the industry standards, hide that from a judge, what the industry standards were. Well, of course, the other side got their own experts and they found out what the industry standards were anyways. So what happened was this placement agency recommended, sent, I think it was a temp and then turned into a temp to perm. The company hired an employee and nobody ended up checking references. The company, she worked for the company for a couple of years. During that time while she was at the company, she defrauded the company of a whole bunch of money, hundreds of thousands of dollars. And they didn't find out that she defrauded them for hundreds of thousands of dollars until after she quit. I think she got away with funneling money out of accounts payable into a separate bank account to the point where she thought, I better get out of here before I get caught. And then, of course, after she left and the new people started doing the job. So the person was sued by the company and they got a civil judgment against her to repay the money. Additionally, the company sued the employment agency for negligence on the basis that the agency did not conduct reference checks or background checks on the employee, because it turns out that this particular employee had done the same thing from a previous employer and had got caught. So it was found prior to joining Treaty Group, the employee in question had twice been criminally convicted of fraud against previous employers. After joining Treaty Group's accounting department, the employee walked away with an additional $263,000 that she stole. They reported to the police. She was convicted criminally. They sued her civilly. They got a civil judgment, and they went after the agency also for civil judgment to recover some of their money. The Treaty Group was successful against the agency, although the damages award was reduced by 50%, because Treaty Group, as it turns out, had hired another consultant, a business consultant, to help them to do their staffing plan. And the business consultant said, yeah, we got to turn this into a full-time job. Let's hire somebody. And the business consultant told the Treaty Group that they would do the background checks and references. And the business consultant told the agency that the business consultant would personally do the background checks and references. The business consultant did not do the background checks and references. And the agency did not do the background checks and references. There was some indication at discovery that the agency had made an effort to do background checks and references, and they got some very limited information from a previous employer. It's possible, based upon the scribbled notes, that the previous employer didn't tell them that there had been criminal convictions for fear of disclosing confidential information or something. Don't know that. It's only that the scribble notes about the reference check was that they were having difficulty getting them. And then when they did speak to somebody, it wasn't very thorough. So some of the issues that arose, some of the issues that came up. There was no signed service agreement between Treaty Group and the agency. It was all done by word of mouth. There was this consultant, this intermediary consultant, who had some responsibility. There was a difference between reference checks and background checks. And it seemed in the court case, the lawyers for Treaty Group used the terms reference checks and background checks interchangeably. And in their statement of claim, they used them interchangeably, when in fact, a reference check is when you talk to a previous employer, and a background check are things to verify about criminal convictions, to verify whether or not a person's educational certificates are accurate and truthful, to verify, in some cases, things like credit worthiness in jobs where that's a bona fide occupational requirement. So background checks have to deal with other things other than the reference that the previous employer would offer. There's the possibility of dishonesty regarding these reference findings. So these scribbled notes about the reference checks. Did the consultant get information and say, I shouldn't write this down? Because there were some notes that were not discernible, and they might have implied that the person was getting the accurate information, but then ignored it. And think about that too. So you don't do a reference check and you place a temporary worker into an accounting job or a office manager job where there's a lot of accounting and access to banking, so on. You don't do a reference check. And then they say, we want to hire this person. They seem to be doing a pretty good job. Do you have information on their references that you can share with us? So then the consultant goes, oops, no, I don't. But they don't say that. So they go out and try to get some references so they can, after the fact, have information that will justify their placement. And they get limited information and or get information that says, oh boy, I should have never placed this person in that temp job in the first place, they're a criminal. They've stolen from all the employers that I talked to, and I didn't know that, and I put them in there now. So does the consultant not find that out? And so it's a mistake? Or did the consultant find that out and cover it up? We don't know. Mistakes are bad. Making a promise to do something and not doing it is bad. It's unethical. Mistakes aren't necessarily unethical unless they're caused by some witting known behavior. But hiding the honest answers is absolutely unethical, and it's unclear what happened here. And so the judge reduced the amount by 50%. There were some issues, industry norms. So my report, there were some issues about them finding out what the industry norms are and then not disclosing them to the court. There was the company made promises on its website about guarantees and background checks and reference checks, and maybe use the terms background and reference interchangeably. Although it wasn't in a contract, they had put it in the public domain. That was a standard part of their practice. The client's lack of checks and balances in their system, the fact that the client went for 2 years with an employee writing checks to fake companies, accounts payable checks to fake companies that had bank accounts in her name, and no one ever figured this out. That's some of the onus goes on the company. And then, of course, how you calculated all that, because some money got recovered. These were all issues that were brought up in court. So, of course, we never want to make up references or ignore those favorable references. We never want to alter or fail to disclose test results if they don't pass a test or do great on a test. We don't want to avoid seeking approval from a candidate before we submit their resume. And of course, we don't want to falsify any information at all, particularly background screening and information about their credit worthiness or their education or their criminality. Principle number 4, we will supply candidates and employees with complete and accurate information as provided by the client. So now this principle flips it on end. Up until now, we've been talking about providing accurate information to the customer, but it's equally important. And the reason why ministries of labor have introduced employment agency and temporary help agency licensing is because the allegation was that employment agencies and temporary help services are not being honest to candidates, that they're telling candidates something about the job that's not true in order to entice them to leave their current job or to go on this assignment or to stay on a particular assignment. So this principle was set out a long time ago that will supply candidates and employees with complete and accurate information about their job descriptions, their workplace conditions, who they're reporting to, the customer's type of business. So here's a case. We placed temporary with our client as a data entry operator, base alphanumeric data entry. When we contact the employee a few weeks later, we find out that they're not only doing data entry, but they're also using more sophisticated software like MS Project to track milestones and run reports and do metrics reports. And they're working in Excel, and they're creating pivot tables and lookups, and they're running weekly analysis and building charts, and they're providing this to the client. The client's getting a great deal, paying the data entry level and getting a super project assistant service. Is this unethical? Yeah, it is.
Yes.
Do you think, doesn't say, do you think that the consultant, when they took the order for a alphanumeric person, knew that this was not a data entry job? Nothing indicates in here that The person knew, right? They found out 2 weeks later. This one is subtle. Like, I don't know. Like, are you happy? Do you feel satisfied? Um, are they treating you well? Um, is it like you expected? And the person might say, "Oh God, I love this. I mean, if I was doing data entry all day long, I'd be bored to death in my carpal tunnel syndrome. Oh my goodness, my hands and my wrists. I love this. This gives me a chance to work with people and talk to people and use my skills." So is it unethical? Well, if it's a 2 or 3 month temporary assignment, I don't know that it is. I don't know that the customer has got some sort of moral obligation to say, boy, I got great value from you. I'm going to give you a raise. If that was the case, we should all get a raise. Because, of course, we think we provide great benefit to our employers. And boy, if they paid me what I was worth, I'd be worth $1 million. I generated $2 million in revenue last year. So we'd all be getting raises. So I don't know that this is unethical. So what would have made it unethical? It would have been unethical if the customer knew that it required all these other skills, but intentionally selected a job category from the, say, for example, the schedule to pay lower, right? So let's imagine, say, for example, a federal government contract where they literally have 6 levels of administrator, admin 1, 2, 3, 4, 5, 6. This one's $22 an hour. That one's $30 an hour. That one's $40 an hour. That one's $60 an hour. They want somebody with the skills of the $60 an hour, but they want to pay the budget of the clerk level one. So they put a request in for a clerk level one, and they wait until the agency submits a resume of a person who's highly overqualified. That would be unethical. That would knowingly be using the system. So I'm going to untie a knot here. That would be knowingly using the system to circumvent its intent and to intentionally underpay a person for a different job category. That would be unethical. If we found that the person was a vulnerable worker, a recent immigrant to Canada, or someone who was a single mom and they needed the job, and so we offered them less money of a lower category and misclassified it in order to get their high skill for a low price, that would be unethical. In this case, with the limited information available, it's like I needed a data entry person. This person came. They're supposed to be here for 3 months. Wow, they did a great job. They did all kinds of other stuff too. We really liked them and respected them. They obviously loved their job and did a wonderful job. I would have that person back anytime, and I'd have them back at the other job category. So it's not necessarily unethical, but there's all kinds of implications in here that it could have been, maybe was, maybe there's things that's not in here, but it's not unethical, particularly in a short assignment, to say this person did a great job, and I didn't give them a raise. That's not unethical. You hire a person for 3 months to do a job, they do a great job. You've got no obligation to say, I'm going to pay you more money than I promised. It's just the way it goes. The Ontario Employment Standards Act requirements, it requires that a temporary help agency nowadays is required since 2011, I believe, to provide the following information to an assignment employee when offering a work assignment to the client. They have to give the legal name of the client, as well as any operating names or other names. So if the person is part of a franchise system, we have to say, hey, this is ABC Corporation operating the XYZ franchise, so that they know exactly who they're doing business with. You know, it's I don't know, Tim Hortons. Tim Hortons are owned by franchisees, and every location is owned by an independent business operator, and they work under the rules of a franchise agreement, and they get to use the name Tim Hortons. But when a person works at Tim Hortons, They're not working for Tim Hortons, they're working for the franchisee. So we've got an obligation to be forthright with people to understand who they're working for. That, you're not working for the head office of Tim Hortons, you're working for a franchisee of Tim Hortons, and their company name is this, because that's what's going to be on your check. We have to know, they have to give them the contact information of the client, including the address, the phone number, the person's name. We have to tell them what wages they're going to be paid. It's not good enough. Tell a person, oh, we'll figure out what you're going to get paid later. It's not good to get them started and then tell them at the end of their second day. We have to describe to them the hours of work that they're going to work. Now, by the way, there's no law anywhere else for any other job that you must tell a person the hours of their work. Now, most employers have an employment agreement that says thou shalt work 40 hours a week. They might say thou shalt work by the hour and work up to 44 hours a week. They might say this is a shift job and you rotate between day, afternoons, and evenings on a fair basis on 12-hour shifts in our hospital. They might say that. But in the legislation specific to temporary help agencies, we must tell them the hours of work, when they're expected to start and finish. Because the allegation was, prior to the existence of this legislation, that we were taking advantage of temporary workers' vulnerability, and that we would maybe send them home early and not pay them, or keep them for an unusually long number of hours, and maybe threaten to them, if you go home, you lose your job. So they expect us now by law to tell a person before they start their assignment how many hours are required, what days, and schedule that work is going to be. A general description of the work. So providing as accurate as you know. The estimated term of the assignment. How long will it last? The pay periods. How you get paid once a week, once every 2 weeks, once a month, bi-monthly, semi-monthly, sorry. So the pay periods and what the pay day is. This information can be provided anyway. Verbally, over the phone, when it's offered. It must be provided in writing as soon as possible. So you can talk to a temporary worker over the phone, describe it to them, they say yes, you go great. And then as soon as possible, that evening, that afternoon, the next morning, you get the documentation out to them so it all gets confirmed. So, for example, in one of my companies, everything is done through an app. So every employee has an app. They know exactly where they're going, what their schedule is, when they're supposed to start, stop. They clock in with it. They do all that with their app. And so we phone them and say, hey, Joanne, would you like to have this assignment to go here at this time, at this pay, to report to this company, to do this job? The job description is this. And they go, yes. And they go, great. I'll get it into the app. And then sometime in the next short while, the system is updated, and then the employee has it available to them. So that's an example. In another company, as soon as the job order is filled, automatically a copy of that job order and all of the information is emailed to the employee that accepted it. So there's different way you could do it just by handwriting it. There's different ways that you can provide this information. Principle number 5, we will not recruit, encourage, or entice a candidate from whom we have previously placed to leave the employ of our client, nor will we encourage or coerce an individual to leave any temporary assignment before the stated completion date. So these are two somewhat similar but different situations. The first one is what we often refer to as an anti-rating clause. This is to not headhunt the person that you placed out of the job. Of course, that would be just on the face of it, without even attending the session, to charge a company money to place a candidate into that job, and then to steal them away from them and place them somewhere else and charge money for them, and then steal them away and place them somewhere else, is probably the epitome of unethical behavior that you can imagine in the recruitment and staffing industry. Very often, customer contracts have got a clause that talks about anti-rating. Maybe that you not only can you not ever recruit that person, but you can't recruit any of their coworkers either. Because while you're doing it, you got access to confidential information about the company and about the people who work there. And so why would a company want to do business with you? If they want to do good business with you, they tell you everything in an ethical fashion, and then you use that knowledge of everything to recruit their employees away. Of course, that would be an unethical business practice. And this other notion, the second notion of encouraging or coercing an individual to leave a temporary assignment. So if our competitor has got somebody who's supposed to finish a week from Friday, and we go out of our way to get them to leave today without notice to start with us tomorrow, and we coerced them by threatening them, you'll never work for us ever again, la la la, or enticing them, I'll give you a bonus if you quit, walk out the door and come here now. These are enticing, encouraging, and coercing an individual in a manner that causes harm to our industry. So even though you might get away with it, as previously stated, it's not just important to know and understand the law and to follow it because you might get caught. It's important to do the right thing and know what the right thing is. So asking a person to violate the terms of their contract, to lie about their intentions, to breach their agreement in order to benefit you would be a violation of principle number 5. Under what circumstances will you entice a candidate or employee who has been previously placed at a client site to take another role you're working on? Well, we just said never, right? Let's look at the examples that they're going to give us here. When you place the candidate on the client, when you place the candidate, the client, when you place the candidate at the clients and the position has turned out to be less than the client promised. So you charge the client money, you place them into a job, and it turns out that the candidate doesn't like the job. I don't think that's a good enough reason to violate your promise. Let's look at B. When the candidate or employee approaches you saying that he or she will leave the company. Look, I'm looking for a new job. I know you placed me here 2 months ago. I'm looking for a new job. I'm going to be leaving here no matter what. I don't like this job. So you can make some more money if you place me somewhere else. I'll let you. The answer is no. Because if I get involved with you now, I'm participating in helping you to violate my obligation to that client, our obligation to that client. So I'm just going to not be involved. Let's look at number 3. When the person is obviously unhappy in their current position, I think that's just the same as number 1. The answer is no. When the client's planning a layoff sometime in the future. This is the one that I say, okay, if the client says to you, we absolutely will be laying off everybody in the fall. As soon as we finish this project, we're going to be letting them go. We're going to be putting together packages to entice people to leave, and people are going to get this stuff. But, if some people left voluntarily over the course of the summer, that would probably make everything a lot easier because now we don't have to decide between employee A and employee B and so on. So if you happen to see any jobs and you want to help Mary find a new job, you've got permission to do so. Otherwise, we're going to lay her off in September. Well, that's perfectly fine. That's perfectly fine. You got permission from the client. But just suspecting that there might be layoffs is never enough. And so the answer is under no circumstances is it acceptable. That's the real answer. And number D has got this. Yeah, but if you get permission because it's in everybody's best interest, the employee's best interest, the customer's best interest, there's permission and full disclosure, then of course D could be the case, but it's not the case on the face of the way it's just written there. Okay, so what to do? Let's go through some scenarios. A recruiter
I
needs to
have a
fill another role.
question.
Yes,
With regards to the previous slide, let's say you've placed a candidate permanently and it's been like 4 or 5 years. Still, we cannot go back to the same candidate.
correct.
Okay.
Yeah, never.
Okay. Thank you.
Okay, discussion what to do. A recruiter needs to fill another role ASAP, and the margin in this other role is higher than the other jobs that we have. The recruiter wants to pull an employee from big customer low margin so that they can place them into new customer high margin. Is this acceptable? The answer is no. It is not acceptable because the principal said that we will never encourage or entice a person to leave, and we'll never recruit out of. We'll never encourage and entice to leave a job or to leave their assignment early. So the fact that we got a new customer with a new job order, we either finish that job order and then the next job order they go on is with the new customer, new margin, or we find another candidate to go there, but taking people out of one customer to go work at another is not an ethical conduct. The employee tells you they have another opportunity and they want to leave this assignment. I don't know. You've got to, I mean, there's so many subtleties. You place a person on an assignment with your customer, and then the candidate calls you and says, I've got another opportunity. I'd kind of like to leave. Doesn't say that they are going to leave, it says they want to leave. So, what? The employee is on a temporary assignment that lasts for 3 weeks or 5 weeks, and it pays moderately, and they've got a chance to go get this great job that is exactly what they wanted with great money and benefits. And they're going to give you some notice. They're going to give you 2 weeks notice that they're going to take this other job. The ethical thing is to say, okay, let's talk about what the potential is here. I'll be honest with you, the potential there, and let the person make their decision. And you respect their decision because they've given you notice and their life is going to be wonderful. And then you communicate that to your client and you tell them you'll find a replacement and you find them a replacement. And you go through the process of finding a suitable replacement. This stuff happens all the time. What would be unethical? What would unethical would be to make promises about what's likely to happen in this assignment to make it look like it's super awesome compared to the new job so that they'll stay. But you falsified or exaggerated information to convince them to stay for your benefit and for the benefit of the client, but to the detriment of the worker. That would be unethical. To kick them out and say, oh, you dirty dog, you undermined, bad stabbing person. I gave you this job and now you're going to quit. Get out of here. I threaten you. I do something bad to you. That would be unethical. Not respecting a person's right to choose who their employer should be and what is in the best interest. That would be unethical. So the fact that they told you got another assignment on itself doesn't have any implications in it whatsoever if it's all done with notice and full disclosure. How people react to it could be unethical. The recruiter, number 3, the recruiter locates a candidate who is currently working for a competitor on a 3-month assignment. They would be perfect for the job order you have now that you're working on, and you could give them a raise. Well, people can quit jobs. People can give notice on quitting jobs. People have terms in their agreements to give notice to quit jobs. If you say to a person, hey, I got a job, it pays this amount of money, unfortunately, you would have to start soon. But I want you to leave your current job and not give notice because I need you to start Monday. That would be unethical. If you said, I'd like to encourage or entice you to leave your job early and cause harm to the employer, the other employer and customer, that would be unethical. If you if you presented the job offer on its face and all of the terms of the agreement are followed and all of the notice is followed and the person has the right to make their choice without feeling overly excessively encouraged, enticed, or threatened of a reprisal, if they don't, then it would be ethical. But if we threaten the person against reprisals, if we use unfair enticements to make them leave early, if we ask them to breach the terms of their contract and not give notice, those would all be unethical behaviors. So on the face of it, if we follow the principle, we're not supposed to encourage or entice. It doesn't mean that they can't leave early, but we're not supposed to use unfair business practices in order to get them to leave early. Principle number 6, which is exactly where I just went. We will not restrict the right of a candidate or employee to accept employment of their choice. So while we won't encourage or entice them, we'll also respect the fact that when they make a decision, it's their decision. Principle number 7, we will not misuse membership privileges for the purposes of recruiting. So this is pretty straightforward. You're an ACSESS member, you go to an ACSESS member event. You go to a chapter meeting or a conference. While you're there, you don't use that conference, that permission to attend, to recruit your competitors' employees away. So I think we are recruiters. Our skill is recruiting. We belong to an association that is about the ethics of recruiting. So we join the association of recruiters to help promote the ethics of recruiting. And then we go meet with other people to learn and talk about and share the ethics. But while we're there, we try to steal them from our competitors. Or we collect the information about who attended so we could try to steal them later. If on the face of that, it doesn't seem like a pretty decent principle, then I don't know what to say. And yet still some people think, hey, well, I didn't do it at the meeting. I didn't download the list. So there's nothing wrong with recruiting. There's nothing wrong with running an ad. There's nothing wrong with taking an application. There's nothing wrong with getting a referral and contacting a person. But when you start to use confidential, proprietary information or information that was provided to you for an alternative expressed intent or purpose, and you use it in a manner to unfairly bring you benefit to the cause of harm to others, it's unethical. True or false? This is an acceptable method of recruitment. True. Oops, sorry. The analogy. The company agency that you work for has just experienced a 90% turnover in their branch. Everybody's quitting or getting fired, and they need to recruit. ACSESS has an association meeting. So you're going to attend and assure that everyone at that meeting knows that you've got jobs available. We just talked about that. Don't do that. There's no problem in placing an ad the next day in the newspaper, but don't go to the event with the intent of recruiting. Principle number 8, we will derive income only from clients that make no direct or indirect charges to candidates or employees unless specified by a license. Okay, well, the specified by a license thing is kind of weird because maybe back in the old days there were actually specific licenses about things, but I don't really know what license would exist. The rule is, listen, do not charge candidates. Charge your companies, your customers. Don't charge candidates. Don't charge them for anything. Don't charge them to redo your resume. Don't charge them to take your course. Don't charge them to get a job. Don't charge candidates. Don't charge them for their lunch. Don't charge them for their uniforms. Find a way for everything. If a person wants to go buy a uniform, let them go to where you sell uniforms and buy it there. If a person needs to, you know, a lunch, let them bring their own lunch or give them a lunch allowance, but don't charge them for a lunch. So, um, even though you could legally, even though you could legally say, hey, you could buy your scrubs for your caregivers from us, it just opens up a Pandora's box of saying, how you deducted the money from their check. There's all kinds of laws about deducting money from their checks. Did the person feel as though that they were obliged to pay you money in order to get this job? Did they have to buy this from you in order to get the job? That's illegal. So, charging any money directly or indirectly to a candidate is just unadvisable and against the principles of access. We will maintain the highest standards of integrity in all forms of advertising. Communications and solicitations will conduct our business in a manner designed to enhance the operations, image, and reputation of the industry. So putting a accurate job description. If you're going to put wages, or if there's legislation in your jurisdiction that you must put wages, that you put wages accurately. That the job description that you know of is accurate. These are all that the things that you say about your company, about the type of insurance you have, that it's truthful and accurate. About the number of offices you have, truthful and accurate. These are all important parts of our principles. So integrity in advertising. So keep posts up. I think some of these, are they all of those still around? I don't know if they're all still around. Keep posts up to date. So putting up a posting that's really old and out of date is not necessarily the most ethical thing to do. Make your posts accurate. Only post open jobs. I remember when I first entered the industry 1,000 years ago, there was a company in Toronto that was always recruiting for airline hosts and hostesses. They never had jobs for airline hosts and hostesses. They were all administrative jobs. And what they knew was that people who wanted to be airline hosts and hostesses probably possessed certain skills, customer service skills, looks and appearance. They made some generalizations about airline hosts and hostesses, and that some airline hosts and hostesses back in those days didn't always work full time. Those were part-time jobs. They were on call. And so they'd get these people that met the description of an airline host to be data entry operators and receptionists and clerks and office clerks and customer service representatives. And they ran these jobs 7 days a week. There's another company that ran advertisements about executive jobs, but what they were really doing was selling executive outplacement assistance. So they'd get these executives to sign a contract to get assistance on training and assistance in finding a job, but they didn't promise them a job. Make your posts accurate. There's the bait and switch days are done. Certainly not available and not appropriate for an access member and not appropriate for our industry. Accurate pay rates. In some jurisdiction, legislation exists about pay rates. Be careful with the intended or implied violations of human rights. Millennials, violation of human rights. The example we gave earlier. In the absence of absolute permission, don't mention your customer's name, or even write the job description in such a way that everybody knows who your customer is. One of the reasons why you've been asked to advertise for a customer is to protect their identity so that they don't get swarmed by candidates. Protect the candidate's privacy. Acknowledge applications. It's an ethical, good business practice to at least say to a candidate, Thank you very much for your application. We received it. It's going to go into our database. Somebody's going to assess it. We'll determine whether or not, based upon the face of the information in your application, that you possess or will possess the necessary skills for our available job or jobs. If it appears as though you have the qualifications, someone will be in contact with you. If in the event that you're not qualified for this job or the job is filled, we will keep your application on file and we will assess it and contact you if we think that your application is suitable for future jobs. That's a long-winded letter or auto email, but acknowledge the fact that you received it. At least say something like, only candidates, so long as the job is still available, only candidates with skills and experience necessary for this job will be contacted. At least acknowledge it. Pay attention to the wrapping and auto post features for professional display. Wrapping and auto post. What does that mean? That means that you've got a job board that takes, or a poster like Career Builder or Monster, Glassdoor, Indeed, that will take your jobs that are either in your system, your applicant tracking system, or in your system, your job orders, or they'll take them from your website, or they'll take them from an HTML file, and then they will repost them onto their job boards. And they call it wrapping or auto post, and they generally are pretty slick. You know, the intent is to say, for example, put it into your system, into your applicant tracking system, and to your customer contact management system, and your job order goes in there that you're going to work on, and that your website, if you click a button, says put this on the website, your website wraps it up and puts it on your website, and then the job board, the third-party job board, takes a look at your website or takes a look at the file that was created to create the jobs on your website, and they every day or every minute upload those files and they synchronize what's on their job board with what's on your website or in your system. And it's pretty cool. And it works and it's efficient. And sometimes it implodes because the mapping of the data into the fields or the places on the job board from the XML file or the HTML file or the job posting that you have don't map perfectly. And sometimes even if it's going into your system, it may be pulling out notes about the client or the job or about something that was never intended to be posted on the internet. So be careful. Pay attention to it. Most companies, in my opinion, should have somebody who every day takes a quick look at all of the places where you post jobs just to make sure they look right and they're not posting information you're not intended. This is a terrible advertiser writer with errors and mistakes and years and typos and spelling mistakes. And this is just absolutely unprofessional. And so, in terms of ethical behavior, not so unethical. In terms of business practices, this is terrible. So, one of the advantages of auto posting is that if you get it right once, it goes everywhere right all the time, except for when it doesn't, except for when it breaks, when that mapping doesn't work. And when you allow individuals to write jobs on a one-by-one basis, the opportunity for them to make mistakes like this, or to write something that's inappropriate in a discriminatory fashion, or to fail to disclose confidential information unwittingly, all of those opportunities exist. So the more automated it is, the more likely it is to be accurate and correct. And also, the more automated it is, the more likely it is that when it goes wrong, it will go dramatically wrong. So let's talk a little bit about social media. Also, let's talk about what time it is. 9 minutes. We're going to take a break. Social media. Is social media at work? Think that how you use social media at work should be extended outside of your regular work hours. So here's a couple mindful points. Be mindful that your postings will be available to the general public. So when you post something on Facebook or on the that everybody's going to see it. Once you post something, it lives there forever. You can delete it. That's not the way the internet works. There are sites that their entire purpose is to capture what existed at certain points in time on the internet and to save it. So you could go and take a look at what did this website look like 2 months ago, 2 weeks ago, 2 days ago, 2 hours ago, compared to what it looks like now. Once it's out there, it can be downloaded and synchronized. And you post something to Instagram and it goes to your Facebook account. You post something on your company Facebook account and it ends up at your personal feed. There's all kind. You put something to Twitter, it also goes to YouTube. There are just all kinds of integrations, relationships, uploads, mapping. And then of course people can forward things, they can copy and paste things. So once it's out there, it's out there. Express your own opinions. For example, the example might be the views expressed on this website or in this posting or this weblog are mine alone, and they don't reflect the views of my employer. You could do that. I would suggest that if your views are inconsistent with the views of your employer, that maybe it's not in your best interest or your employer's best interest to be using social media to do that, to show your differences. It happens. Facebook is a perfect example. Most companies have a Facebook page. People can join and follow a Facebook page. Lots of people on their Facebook personal say where they work. Like LinkedIn, you can link together your information about where you say you worked and the company's company page. Now, your personal profile is linked to your company page. So what goes on the company page could potentially reflect upon you and your reputation. And what you post on your page could reflect upon your company's reputation. So we also know that Facebook, I'm using Facebook as an example, I'm not picking on Facebook, that Facebook and Insta can be a great place to promote your jobs. They can be a great place to attract interest. They can be a great place for you to promote your personality and your profile and your professionalism. They can be a place where you can post stories and things about how to do a great interview and what's going on in the marketplace and who some of the fastest growing employers are and what some funny stories are about job interviews and about job postings. There's all kinds of things that you could be doing, keeping in mind that they will live forever and that a company can't force you to use your personal Facebook account or social media account to promote the company, but they can require you to manage and maintain a company account. If that's part of your job and part of your job description, thou shalt maintain the company account and use your persona, your work persona here, they can require you to do that. Just don't link it to your personal account. So posting on LinkedIn, is that a company? If you work for a company, does the company have control? And you link it to your company, how much control does the company have about what you post there? And of course, most recruiting companies think that you're going to be a better recruiter if you're constantly posting great content. yet who decides what's great content? So be mindful of these issues. Do not disclose confidential information, proprietary information, or commercial sensitive information about anybody, any place, anytime. Even if it's your personal account, when you start telling information, confidential information, email accounts, phone numbers, and posting them on the web, you could be getting yourself into trouble. Ensure that your conduct outside of the workplace would be acceptable in the workplace. So an example of that is, my goodness, in today's day of fractured political views, imagine that your company gets grants and sponsorships and things from a government agency, and yet, you or one of your coworkers has a visceral disbelief in government. And so they're constantly saying things, and yet their profile is associated with your company, and then they undermine your ability because they've disclosed some information or said some information to get those government contracts or subsidies or something again in the future. You just can't ever know that once you put it out there that it won't be found. That if you're going to party and put up questionable photographs of what went on in your personal life at the parties, and they're going to somehow find their way associated to your reputation at work and what customers think of you, and so they may not ever buy from you again. Now, companies have a right to tell you how they follow you. Companies have an obligation to tell you how they monitor you. Companies have an obligation to respect your personal privacy. Employees, on the other hand, don't have legislation. They only have civil lawsuits and employment agreements, but no laws that protect the company. But know this, that if you do things on the internet that cause harm to your company, it can be cause for dismissal. Principle number 10, we'll recognize and respect the rights and privileges of competitors in a true fashion of individuality and initiative and free enterprise. So this means don't steal other companies' information. Don't hire people on the premise that when they come to work for you, they're going to tell you all of their trade secrets. So we need to respect the rights and privileges of our competitors, including their prices. Okay, we got one more minute. So what are some issues related to, before our break? Fair competition, recruiting from a competitor to get access to confidential information is considered unethical. When people work for a company, they sign confidentiality agreements, and even if they didn't sign it, they're implied that they're given confidential, competitive information to be used for the express purpose and intent of benefiting that business. I give this information to you so that you can use it in a way that will help us grow, that will help us succeed. And if I pay you and I give you this information to help us grow and succeed, and you quit and take it in your head, it is tantamount to theft. But we can't remove it from our head. It's in there. So once we take it and use it in a manner that is intended to cause the benefit of others at the harm of the person who gave it to you, that is a violation of your competitive obligations and to your fiduciary duty. And so we don't go out and recruit and hire people for the express purpose of stealing the information that they've included. A tortious interference or workforce transfer is also an issue. Tortious interference or workforce transfer is when we go bid on a contract, knowing that if we bid really low, for example, and we win the contract, that we're going to get access to all of the information about the temporary and contract workers who are there now, and we will coerce, entice, and use confidential information about them to have them transfer over to my payroll, your payroll, so that you do not incur the expense of recruiting them, finding them, using the skill to entice them and attract them to your business, that you simply unfairly collected competitive information for the purposes and then used it for the purposes of causing harm to them for the benefit of you or others. If you know that your competitor has already submitted a candidate says, oh yeah, Steve sent my resume to them yesterday. So you go ahead and package that resume up and send it to the same customer for the same job today, hoping that maybe because it went on the top of the pile, it'll come off the pile first for you. That would be unethical and inappropriate business behavior. We want to adhere to all legislational requirements and contract terms, and we do not want anyone to, we're going to get into the abuse of market dominance. Okay, guys, so it is now 2:32. We're going to go take a break till 2:42. Our intention is to be done before 4 o'clock today. As usual, please keep your microphones and your cameras off. I'm going to pause our screen here also. And if you leave the room, it's possible that you're not going to get back in again easily. So we'll see you back here in 9 or 10 minutes. We'll finish up these principles and we'll move on to the next stage. Thanks. Come back again. Moving on to principle number 11. And this is the overarching guiding principle that will ensure that our clients and candidates and employees are aware of our duty to abide by this code of ethics and standards, and such supporting policies and access guidelines as may from time to time be adopted by the association will undertake to bring any potential infringement to the association body. So let's talk a little bit about what scenario. Let's do a quick scenario. Hiring manager of Fish Inc. is looking for 4 people to work at the welcome table at an upcoming conference. The conference is expected to be about 1,000 attendees, and they will need 4 people to welcome guests and to check them in and provide a swag bag for these attendees. So the conference outline is about companies promoting ocean fishing, everything from the themes of geography and ocean currents to equipment and safety and environmental impact. The welcome table greeters will need a uniform of a white blouse and black shirt. So the term blouse implies that this is only female guests. And so we might want to change the wording of that to a white top and black pants or skirt. And that way we're not going to do role playing because of the nature of the meeting today, but we might want to change the wording of that to be more generic to not imply gender in the job description. Always the right thing. So specifically things that we could do. We can audit our internal documents and practices. We can look at our written policies and practices. We can take a look at our service agreements, our documents, our employment agreements, our policies, practices, and procedures manuals, and we can ensure that they do not unintentionally, unwittingly, or even intentionally including business practices that would violate the code of ethics. We can create templates for job postings using technology in a manner to make sure that our job postings are accurate and consistent and professional in the manner in which they're posted. We can provide thorough training to our employee and all of our employees to ensure they understand all of our legal and professional obligations and expectations. We've got an opportunity to promote a culture in our organization that influences the treatment of all candidates, employees without any form of prejudice, in our equal opportunity and fairness. We can create a company code of ethics or operating guidelines also that is consistent with and more detailed than the ACSESS code of guidelines. And we can post our company and or ACSESS code of ethics and guidelines somewhere. So we're going to talk now about business practices and guidelines, and then we're going to move on to some of the things that we can do in managing our business. So it's important to have operating guidelines within our industry, like most industries. And some of the examples of these guidelines are listed here. They are available on the ACSESS website for members through the members only section. So I'm going to talk about them a little bit now. There's screens further on, so I'll skip by those screens later on. But a workforce transfer guideline or transition guideline, that's when a company wins a contract that has another company as the incumbent, and it deals with the issues of what happens to all of the employees who are on assignments or contracts at that company on the transition or guideline date and leading up to the transition or guideline date. What are our obligations and some best practices and procedures? We've got a guideline with respect to servicing a customer during a labor dispute. So their employees are on strike. We'll talk a little bit about that in detail. Determining the right of referral. So what happens when two agencies present the same candidate unwittingly or unknowingly for a job? How do you determine who has the right of referral? Who's going to get paid? Headhunting for staffing professionals. So we're going to talk about, we already talked a lot about that, about recruiting from your competitors. We'll talk a little bit about the Compliance and Competition Act. Assignment completion dates. We talked a little bit about that already, and we'll talk about the issues associated with failing to provide completion dates and what some of the things that can happen. We've got obligations around and policies around hazardous materials in the workplace and workplace hazardous materials documents. We already talked to some degree about discriminatory job orders, and we will mention application forms. So when you go to the website, you'll find a page that talks about operating guidelines and business practices, and you can click on any of these hyperlinks in blue in order to read and download the full articles on each one of these. So a workforce transfer. So you've been the sole supplier to Thompson Tire, which is a provincial chain, and now they're looking to expand across the rest of the country. So they've chosen another company to be the master vendor of their recruitment program, who's in all or many of the provinces. Your company is invited to respond to the request for proposal process to be one of the top 3 vendors in the program, and subsequently you do not win a spot. Somebody else wins the contract. You've been asked to work with the new MSP, the Master Service Provider, to conduct a workforce transfer of your existing employees. So they're asking you to transfer your employees to the other company. You're not happy with this, and you've got 60 temps or temporary workers or contract workers there working with your client, and they've been there for a long period. You worked really hard to recruit the assigned employees, and so you immediately get on the phone with them and you inform them that you no longer have the business with Dusty Donuts. I thought it was Thompson Tire. With Thompson Tire, as well as you plan an early morning meeting on site and coach them to end the assignments in a week's time, and you will place them with another customer location. So what this scenario is saying, you lose a contract, the customer expects you to, or tells you that you're going to transfer all of your employees to your competitor. You don't like it, so you jump in there and you go visit and phone all of your employees and say, no way, Jose, let's make you work, get you to work for us. Well, let's go back, sorry. we've got an obligation under the principles to allow our candidates to choose the employer of their choice. But we've also got an obligation to protect their confidential information. So, on one hand, it was inappropriate if the customer provided all of the candidate, the employee's information to the new vendors. That was wrong. That was a violation of their confidential information. It's probably a breach of your contract with them that they disclose proprietary and confidential information about your company and your employees to a competitor. The fact that they've obliged you to or think that you will participate is presumptuous, at least. And yet your response by trying to coerce or entice the people to leave prematurely, say the contract doesn't end for another month, and you're asking them to leave now, is also a violation of the code of ethics, enticing or coercing a person to leave an assignment before its end. The end is at the end of the contract. Then the other thing is, what date did you give those workers as the end of their assignment? Did it correspond with the end of the contract? Did it go beyond the end of the contract? So you made a promise to somebody that's going to be a 6-month assignment, knowing then 2 months from now, the contract might be ended. A whole bunch of issues here that come into play. Respecting the right of the individual to accept their own, who their employer will be, protecting confidential information, disclosing the end date of assignments, enticing or coercing a person to leave their assignment before its end date. There's a whole bunch of things that on balance that we need to consider. So let's also talk about, now, by the way, I think we're going to go into more detail in a few minutes about the workforce transfer, but the obligation is to attempt to negotiate and disclose this in your agreement. So if you sign this agreement 3 years ago to be the supplier, and it had an end date that is in a month from now, and you negotiated all of the terms of what would happen to the workers, what information needed to be shared, not shared, what obligations you had to the employees, what obligations you had to the customer, what obligations they had to you. If that was all in the original agreement, that's a great agreement. If that's not done in the proposal that you made in the RFP and the request for proposal in the RFI, the request for information leading up to this contract award, if you addressed those issues in an open and transparent manner, then that's great. You probably have got a lot of that in writing already. And then when you were leaving the contract, giving information to the workers so that they've got a right to make a decision about whether or not they wish to remain with you at the end of the natural end of their assignment or at the natural end of their contract, and giving them notification of the end of contract, telling them that in some degree with no obligation to provide their information without permission to the incoming vendor, and acting in a way that's not intended to be a reprisal or cause pain or harm to your customer for not awarding you the contract fairly. These are all things that need to be considered in the workforce transfer. So now we've got a candidate that you've presented for a permanent job with a customer who's got a search agreement with you. Who is entitled to the fee when 2 staffing companies submit the same candidate to the employer for the same job? What actions do you take? Where do you go to find the answer? Well, you can go to the ACSESS website and you can find the documents on the right to referral document. And it's determining the right of referral and placement at the bottom of the screen, it says. And you can follow those guidelines. And the guidelines are going to be, when did it occur? Who did it first? Who had responsibility for, who had permission? Did both companies have permission to present the candidate? Did both companies have a bona fide job order? Was the presentation submitted to the documented of the date and time to the employer? If it happened to muddle its way through to a further stage, like the interview and the job offer, who controlled that process and was significant in terms of each step of the process? So the fact that I might have submitted the candidate 3 months ago and the customer didn't pay any attention to it, and you submitted the candidate today and they did pay attention and they did give you a bona fide job order and they did contact you to set up an interview and you did ask for permission from the candidate and you did negotiate the job offer and do the reference checks and the background checks. The fact that I might have submitted it 2 months ago and it fell between the cracks is not enough in terms of a multiple presentation for me, customer company number one, to have a right of referral and charge a fee for that placement. So we also talk about employer of record. We're not going to go in great details about this, but because we talked about this to some degree already about the determination of an employee, or independent contractor status. But here's an example where it kind of gets into the legal but not so legal part of the operational guidelines. Your customer as a contact center, they're a national contractor. They got 40 of your temporary workers there. They've got a company party coming up. You received 3 calls from this week from temporary employees, very concerned and angry, asking why they did not get a gift card at the holiday Christmas party. You also received a call from the hiring manager asking you to deal with these disgruntled employees and ask them to stop complaining. So, hundreds of people go to a company Christmas party, 40 are your employees who are temporary workers there. They got invited to the party too. Gift cards are given out to all the employees of the customer, but not to the temporary workers. The temporary workers think of themselves as employees. So, we got to ask some questions. Did you know anything about the party? How good is your relationship with your employees? How good is your relationship with your customer? Do you communicate often enough to know that this was going to become an issue? Have you spoken with a hiring manager in a long time, or is it out of sight, out of mind? You assume that all's going well, that no news is good news. That's not really the case. Sometimes no communication is just taking a problem that's festering. For example, the problem being that the employees see themselves to be employees of the customer and not your employees, and that they're treated unfairly and different from all the other employees. That's a brewing problem. And out of mind only manifests that problem and exacerbates that problem. It doesn't solve the problem. The Call Me contact center has been your customer for a long time. And so this problem just keeps brewing and brewing all the way along. Could have been resolved through better communication. My goodness, you could have sent 30 or 40 gift cards and everybody could have got the same thing. You could have attended the party on your own. Maybe got yourself invited. So the employer of record, providing site-specific training implies that you're the employer. Determining the pay rates implies that you're an employer. Coaching and counseling employees on a day-to-day basis implies that you are the employer. Managing the workers' compensation claims and safety implies that you're an employer. Administering this general safety training implies and is the requirement of an employer. Providing these perks like the Christmas cards, the gift cards, uniforms, business cards, discounts, access to things implies training, implies that you're these perks, implies that you're an employer. Supervising the workers on a day-to-day basis often takes place by customers, but out of sight, out of mind, removing yourself from that starts to imply that they're the employer when really you've got an obligation to provide something in order to keep your foot in the door. The length of the assignment, a person who's been at a place for 6 months, 12 months, 2 years, 10 years, starts to muddle the waters as to who's the employer. The fact that a person has the right to hire or fire, we talked about this in the other session. The customer has the right to end an assignment. They don't have the right to fire you, to fire the worker. So just because they say the assignment ends doesn't mean they lost their job and they've been terminated. Now, in Ontario, we already know this, that under the Employment Standards Act, there's very specific legislation that says that the agency is the employer. Thou shalt not be confused that the customer is the employer in Ontario. So if the agency is the employer, then does the employer, the agency, take on the responsibility of training, determining pay rates, coaching, counseling, managing workers' comp? So these are all issues of concern. They expect that the staffing services, if retaining employees, order remits appropriate source deductions. So as the employer, the temporary company should be withholding taxes at source and administering T4s and paying employers' health tax, or in other provinces, training tax, or whatever it might be. But determining a person to be an independent contractor when they're not is illegal and will blow up in your face and has got negative implications. And attempting to make them appear as though they're your customer's employee is, again, an issue for future problems. So when we're managing our business and we take a look at things, we want to say, okay, how do we deal with these issues in advance? Is it in our contracts? Is it in our employment agreements? Is it in our service agreements? Is it in the week to week and daily metrics? Are we aware, right box, purple box, of what our clients' behaviors are? Are they acting consistently with our expectations, the contracts, and our obligations? Or are they muddling things by acting, say, for example, like an employer when they're not? How do we manage our candidates' behavior? When a candidate's got an issue, a problem, or a concern, depending upon the nature of it, who do they go to? Do they go to their supervisor, make a complaint to human resources at our customers, or do they contact you, as they should be? And then when they're reporting, and this is the issue that exists all the time in temporary and contract staffing, is that they're reporting to their manager or supervisor at work, at the work site, because they need daily direction, control, and supervision. But their ultimate reporting is to you. So they report to the customer in a supplier customer relationship or status, and they report to you in an employer status. So we know that we can find a lot of these guidelines on the website. I showed you what the website looks like. And not adhering to these ACSESS guidelines could result in not only confusion, but it could also result in a loss of your credibility within the industry, with your clients, with your candidates. It could create liabilities for damages, legal issues. It could result in a loss of business, in loss of business ownership, if the issue is really significant. Could at least result in a loss of clients and a loss of your employees and talents. It could result in injury or death. When we're dealing with safety issues, there was, thankfully, there's not many examples of temporary workers losing their life while on temporary assignments, but it has happened. It happened here in Ontario, near Brampton, a decade ago, when one temporary company was using a company vehicle to transport employees from work site to work site, and they went across a level crossing and got hit by a train. It could happen in a work site where a person has a workplace injury with a crane or a vehicle or a forklift or stacking materials or chemicals. These are all issues that we need to be concerned about the whole time. So an interesting case that I added last year, which was in Alberta, and it dealt with Denny's restaurant. So this was not totally perfectly related to, say, for example, a temporary service provider, but this was a recruiting company that participated in the payroll and other issues of recruiting foreign workers. So the foreign workers who all worked for Denny's got together and filed a class action suit, and they did it under the auspices of the temporary foreign worker program. They used a reputable law firm, and they exceeded in getting not only their certification that they could go as a group and make a group complaint, but they were suing Denny's for $1.4 million. So this happened in 2013, 10 years ago, 11 years ago. It was the first Canadian class action lawsuit brought on behalf of temporary foreign workers. It was against Denny's restaurant. Oh, sorry, I said it was in British Columbia. It's for $1.4 million. The workers allege that they paid thousands of dollars in recruitment fees to this agency that recruits temporary foreign workers. And sorry, I got something on my screen here that's blocking my vision. I'm going to move it out of the way. And they failed to provide the amount of that they promised, and they failed to provide in terms of pay. Denny's failed to provide the overtime and the overtime pay. They failed to provide also travel expenses or reimbursement for travel expenses, and they alleged that this was all in their contract, and it was a breach of contract and a breach of fiduciary duty for unfair and unlawful enrichment to Denny's and to the agency. They also worked to maintain that Denny's was trying to intimidate. So once the workers got certified as a class, in other words, they all became one, then Denny's apparently started to intimidate the workers, saying, if you participate in this lawsuit, bad stuff will happen to you. The court found out about this, evidence was provided, and the court intervened, saying there will be no repercussions. And if there are repercussions, Denny is going to pay for it. There's going to be repercussions against Denny's. And so the workers who opted out of the lawsuit, even though they opted out, were still going to be included. So in other words, to say to Denny's, hey, don't bother trying to intimidate these people, because even if they remove their name from it, their name's going to be put back in. They're going to get all the benefits anyways. So you might as well stop threatening and intimidating people. The court noted that the temporary foreign workers were particularly vulnerable, and that this opt-out provisions that they'll be included in the $1.4 million settlement. So the workers were promised that they would get between 35 and 40 hours per week, and they were often paid a lot less than that. They were informed that they would receive a lot of overtime. The workers were not paid overtime. So they were reimbursed for the amounts, the shortages of hours that they didn't receive that were included in their original promise. They were all reimbursed for their airfare to fly to Canada. They were all reimbursed for the fees that they paid to an agency, which in Canada, as you know, is against the law. And Denny's was also required in their settlement to donate to a migrant workers organization so that this could not happen to other people. So when a client starts to do things like Denny's did, and in this particular case, it really was the obligation of the agency, who at the time, that particular foreign worker agency, seemed to have no interest in managing their clients' behavior. But we've got an obligation to deal with job descriptions and these phone calls that they make to us to deal with it up front with respect to discrimination, or to the example I gave you with the workforce transfer, and where the client may have breached the confidentiality of the worker's information. We've got an obligation to make sure that there's no false information that the clients are providing to the workers about their job qualifications, about the safety on site, and about the financial stability of the customer and their ability to pay. We've got an obligation to make sure that we've got proper contracts and that we go through collection process to make sure that they pay their fees and that they don't breach the payment terms of their agreements. We've got an obligation to make sure that they don't tell multiple staffing companies, oh, this is an exclusive with you, when we know or suspect that they're saying the same to many other companies. We've got to make sure that our clients are not holding themselves out to be the employer or acting as the employer of record when they are our employees, confusing workers, causing people to not necessarily get all of their employee entitlements because the customer has confused people about who is responsible for what. We got to make sure that our customers don't ask for inappropriate screening and standards in terms of how they're going to select people. So, say, for example, asking us to do drug testing or alcohol testing or medical testing when that's not a bona fide occupational requirement, and particularly not a bona fide occupational requirement for their own employees. So why would they expect that of our temporary companies to do their dirty work on their behalf? And communicating with candidates and employees about a workforce transfer. So this whole notion of them going to our workers and saying, hey, if you promise to leave ABC company and go work for XYZ company, we'll award the contract to XYZ company on the promise that you will make it easy for XYZ company. These are all things that we want to talk to our customer about and try to deal with in advance. So, using personal information, lack of concern for health and safety, breach of client contracts, these are all things that are examples on the further page, and this is now just putting it in different terms. So this picture on the right implies that sometimes people make promises to us, but they have no intentions to uphold their promises. We've got an ethical obligation to continue to do this with our customers and with our recruiters. And so it's not only important that we ask our customers who are participating in this, but we got to make sure that all of our internal employees are also participating in our ethical obligations. So we want to make sure our recruiters are not quietly behind the scenes recruiting from our customers, or using our ACSESS membership to recruit new coworkers, or charging fees to candidates, being deceitful to candidates about the job order description, causing people to end their contracts early. And so preparing in advance by doing our research, preparing documentation, and promoting awareness are all important obligations that we have that will mitigate the likelihood that bad things could happen. Your employee is working for your customer on a 6-month assignment. A week before the assignment ends, the employee applies to an internal job opportunity. You only hear about it when your client calls you to say, our employee went through the back channels to get in front of a hiring manager. Oops. So this is acceptable behavior as your candidate only has a few days left. Isn't it? The employee, first off, in Ontario, should know, your customer should know that it is illegal in Ontario for a staffing company to charge a placement fee or a conversion fee 6 months after the worker has begun their work with a client on behalf of the agency. So the Ontario government's put a sort of statutory limit, said, hey, you can charge fees for recruitment, go right ahead. But if you derive revenue from temporary and contract work, temporary work, and they're your employees for 6 months, at the end of 6 months, you really can't put a barrier of a fee between you and a potential new employer. So that's one thing. So the 6 month thing is kind of thrown in there, kind of saying, well, I wasn't going to get a fee anyways. But you also have an obligation, have got contract agreements with your with your candidate that say, hey, you're not going to interfere with the customer's recruitment, hiring, and business process. And that if you wish to apply for a job with them, that you will disclose that and ask for permission. And permission will not be unreasonably withheld. That's a good solution. Now, if the candidate applied for a job through normal channels because the job was available in the public domain, it was on the internet or posted on a job board someplace, you can't really stop the person for applying for the job. So all of these things need to be taken into consideration. Every situation stands on its own merit with respect to the terms, but if the candidate went to the job as a representative of your company to act on behalf of your company for the benefit of your company and your company's relationship with that customer, and if they used access to confidential information that they would have only received while working on that assignment and given access to it because you paid them to go be good on that assignment, and then they use that information in a manner that is going to cause harm to you and your reputation, to circumvent a process that they had in their agreement with you, that they would seek permission and that the permission would not be unreasonably withheld, then the candidate acted poorly. It's not acceptable behavior. But if the person said, look, I'm really looking forward to working for this company in the long term, and they've got some jobs posted on the internet, I'm going to apply with them. Is that okay with you? Can I use you as a reference? The answer to that is supposed to be, yeah, sure. Okay, go ahead. I'm glad to give you a good reference. So the same scenarios can have subtleties that take it from one direction to another. So managing unethical candidate or employee behavior, so things like, do they represent their skills and credentials and experience accurately? In other words, do we do checks? Do we do background checks and verification? If they misrepresented their salary, did we do a reference check and validate what their income was in the past? Do we use a recruiter, say, for example, another recruiter to go apply for jobs somewhere else and then come back and say, hey, I need a raise from you. If not, I'm going to quit because Steve said that he can get me a job for a lot more money. And if you don't give me more money, I'm going to go another job. These are all things that, you should not be participating in to coerce people to leave their jobs. And you should have a relationship and communication level with employees to know that they also should not be attempting to coerce you through threats of harm by using other recruiters. So we all have an obligation to participate and play fairly in that. When we've got candidates who don't follow through on their commitments, I'll take an assignment, I'll start at a date, I'll go tomorrow, I'll do some things. I won't take a holiday for the first 6 months because, I know it's the first month of an assignment and I'm covering for somebody on holidays. These are all things that can be circumvented and mitigated through good written documentation and high level of communication in advance. the going straight to the client. I mean, of course, on day-to-day operational things, where would you like me to file this? You go straight to the client. I've got a problem with the manner in which I'm being treated. We need to let them know and understand that they come to you. You are their employer. So false references, that's an issue too. Um, Access has got a timeline for you to be able to make complaints to Access if you know of another company that's in violation of company ethics. A complaint must be submitted in writing to Access Executive Director. Hey, by the way, there is a complaint process, so we'll kind of go through that. The when a member company has a complaint about another member company, they can, within a reasonable period of time, usually within 30 days of them knowing that something's happened, they can make a complaint to Access, and then Access has got an obligation to look into the complaint on your behalf. We're going to get into that process right now. I don't know why the poll was before the screen, so let's just deal with that. If somebody has a complaint about another company, member or not, complaint must be submitted in writing to the Access Executive Director, in this case, Mary McKinich, and the Executive Director will acknowledge the receipt of that complaint within 7 days. So what happens is that the Executive Director deals with it confidentially, doesn't take it to the rest of the staff, doesn't go to the Board of Directors, doesn't take it to a committee. The Access Executive Director will acknowledge receipt of the complaint, will tell you whether or not, in his or her opinion, is a violation of an Access Code of Ethics. And if they do, based upon the merit of on the face of the complaint, will make an unofficial call to the company that is allegedly committing the violation of ethics. 99.9% of the time, that's enough. I can only think of one example over the past 30 years when a complaint actually went higher than that, beyond that. Because what typically happens is the company either says, I didn't know, what should I do? How can I make this better? And they change their policies, practices, and procedures in order to be compliant with the Access Code of Ethics. Or they say, they pretend they didn't know, and they go, oops, I got caught, and they stop doing it anyways. And they change their policies, practices, and procedures. And so normally it is to the advantage of members when they know that there's a violation of industry ethics and standards to make a complaint to the Executive Director, because it is likely to be resolved. If it's not resolved, it'll go to a special committee of the National Board that is a subset, and it'll remain confidential within that group of 3 board members. Those 3 board members will be selected because they do not have a conflict of interest, and they will make recommendations on how the Executive Director and the association ought to proceed, which could include up to expulsion and refusal to accept membership from that company. So let's talk a little bit about insurance. So this is something that we all kick terminology around and very often don't know exactly what it means. So first off, there's CGL insurance, commercial general liability insurance. This is the big insurance. This is the big broad-based insurance that often has umbrella policies, which means that it's got insurance insuring the insurance. And this has to deal with things like typically slips and falls, equipment failing, people getting in the Steve Martin movie The Jerk, when he put a bridge on people's glasses and everybody thought these are great glasses because you don't have to lift them up with your fingers. It was a stupid movie, but then everybody went cross-eyed because they end up looking at the bridge all the time, and so you would get sued for providing a product that caused harm to people or a service that cause harm to people. So commercial general liability often includes things like insurance on your premises, on your equipment, on unwittingly or unknowingly causing harm to people. I often call it the road runner wily coyote insurance, where accidentally an anvil falls from the ceiling and lands on the wily coyote's head. And so we look for general liability, and these commercial general liability insurance tends to have some very minimum standards that everybody knows what it means in the language, but they often vary wildly from company to company. So just because a company says they have CGL insurance doesn't mean it covers what you want it to cover. And particularly in the recruitment and staffing services industry, there are other special types of insurance that come in the form of riders. So a rider is like a separate policy that's added on to the main policy that specifically talk about the issues of, say, for example, the candidate being sent to a customer and being hired. And so they're no longer your employee, or they never were your employee if it's in the placement business. And if they're in temporary help or recruitment or contract business, that your worker goes and works at another company's site under their direction and control and supervision. So there's often very specific provisions for that. So property insurance, including fire, water, and theft damage insurance, are often included either under the commercial CGL insurance or as riders in that insurance. Very often, particularly in the recruitment agency business, there's errors and omissions insurance. And errors and omissions insurance for the agency covers the agency in the event that the agency makes a boo-boo or a mistake. So let's say, for example, now, by the way, this is what I think of. This is now my opinion. It's virtually useless insurance. It's not useless because some policies are written better than others, and some people understand what it covers, and it does in some policies because of the different wording and people's understanding that it actually protects an agency from something. There's also errors and omissions insurance out there that is virtually useless because of the way that it's worded, and it's really only used by companies to say, yeah, I meet their requirements. Here, I've got errors and omissions insurance. The customer says, thou shalt have $1 million in E&O insurance. And you go, yep, I got a policy. And they go, great, check the box. You can be a vendor. So sometimes it gives you access to business, but it doesn't cover much. Sometimes it covers more. But an error might be this. The agency has got a candidate by the name of Steve Jones, who is a engineer with specialization in civil engineering, building bridges. The agency also has errors and omissions insurance of a candidate named Steve Jones, who is a engineering technologist who has skills and experience in creating CAD CAM drawings for bridges, but so they can make the drawings, but they only make the drawings under the supervision of an engineer who can calculate loads and tolerance and stress, and they know how much steel and how the steel should be designed. Then the technologist puts it into the CAD system and prints it out. So one has the qualifications to stamp the drawing saying this is safe and it's engineering certified, and the other one has no qualifications to stamp anything. And you get a contract, and you are supposed to supply an engineer, and you think you're sending Steve Jones, the engineer, but by accident you send Steve Jones, the technologist, and nobody figures it out for a while because the technologist doesn't know that he wasn't supposed to go. He was asked to go. And he's got the same name, and he seems to understand what's going on. So he goes about doing his job. And then the year later, the bridge falls down because the technologist was asked to do things that it didn't know what he was doing. And so now we've got this errors and omissions insurance that covers the agency because the agency honestly made an error, thinking they were sending the engineer, but phoned the technologist. Hello, is this Steve Jones? Yes. I got a great assignment for you. Great, perfect, sounds wonderful. What an opportunity. So this would be an error. The contractor's insurance is different. This is where the contractor or the agency employee goes on assignment and they actually make they're qualified to go, but they actually make a mistake in their work. So they say that this bridge needs a certain kind of weld or a certain kind of bolt, and they did a calculation error and they made a mistake. And that mistake caused the bridge to fall down. So the agency is not going to get sued under their errors and omissions because they sent a qualified contractor to do the job, but the qualified contractor added the numbers incorrectly and made an error or omitted to document something, causing the bridge to fall down. This would be errors and omissions insurance specifically intended to cover the work of the contractor in a third party fashion. In other words, covers the customer and the agency for the damage that may be caused, the harm that may be caused by the error or omission of the contractor. So agency insurance is the real basic kind, covers the agency from making mistakes. Errors and omissions insurance covers for contractors, covers the work of the contractor for the customer. Directors' liability insurance is when you've got presidents, vice presidents, and executives, along with board of directors and members of the board that create policy and give direction. And that when so a perfect example of that would be, for example, many years ago, ClubLink Corporation had a policy around ClubLink is a golf a company that provides golf courses and memberships to golf courses. They have restaurants and golf courses and bars in their restaurants. They've got policies about serving alcohol to people who are underage or under the appearance of having drank too much. And so they've got the drink smart certifications or whatever it's called, licensing and training and so on and so forth. And at their Lake Joe golf course in the Muskokas, a number of young adults over the age of 18 had been drinking too much. The golf course staff came and asked for their keys and asked them not to drive, and was given assurances that those people who were drinking were not driving. They cut those people off from drinking anymore because they'd obviously had too much to drink, either out on the golf course or in the restaurant. And then the drivers had other sets of keys. They went out and drove anyways. They drove off a bridge, went into the water, people died. The families of the young adults sued ClubLink, and particularly sued also the board of directors, those people who meet 4 times a year to give advice on policies and direction of the corporation, and the directors' liability insurance kicked in to pay for the defense of those directors. And as a result, the directors were not found liable because they had good insurance coverage that paid, and they had good policies and practices that paid for the defense of the directors. But had they won, then that policy then would have also have paid all or some of the liability that came from the lawsuit, opposed to the directors paying it out of their own pocket. Theft and dishonesty insurance, in the older days, you've heard the expression bonding, and you'll hear customers say, "Are your employees bonded?" Well, this is a English term that made its way to North America and Canada that means have your employees met the qualifications to be insured for theft if they steal from the customer And the insurance that protects the customer if the supplier's employees steal from the customer. So nowadays we call it employee theft and dishonesty insurance or riders. In the old days, they say it's bonding, and are your employees bonded? And the implication is, are they safe to come work here? Has somebody vetted them? Have they met some sort of standard or qualifications? And will the insurance company stand behind it? So bonding is theft and dishonesty insurance. The difference between bonding and straight up employee theft and dishonesty insurance is that very often an theft or dishonesty policy covers the named insured. So ABC Staffing Company goes out and gets theft and dishonesty insurance, and it will have a clause that says that if an employee has a manifest intent to cause harm to you, they know they're stealing from you, the agency, then you've got insurance to cover you that when your accountant stole from you. But the important thing is that it says had a manifest intent to cause harm to you, not a manifest intent to cause harm to your customer. So where the term bonding comes in, old school wording, is that when you've got third party insurance that says, does that worker, temporary worker or contractor, will they steal from the customer? And is the customer as a third party, not the named insured? The named insured is the company that bought the policy, the agency. Does it cover the third party, your customer, if the employee steals from them? So we look for theft and dishonesty insurance. We have two levels of theft and dishonesty insurance. One is if it covers the agency from being stolen from by an employee. And then the bonding insurance or the third party insurance covers whether or not the employee or the contractor steals from the customer, and will it reimburse or cover the loss incurred by the customer. Professional liability insurance is often things like having a human resources policy, unaware of the fact that they might have violated some term of an employment agreement or some contractual agreement. So often the commercial general liability insurance, the top one, won't cover a company if they violated unknowingly or unwillingly a term of a customer or an employee employment agreement or a customer service agreement. And very often professional liability insurance will help to cover the harm and liability that is caused when there is a violation or breach of a contract or some piece of legislation. So if you get sued for a human rights violation, it's possible that professional liability will insure a company for unknowingly or unwittingly violating a term of human rights. There's special kinds of insurance, medical malpractice insurance, caregiver abuse insurance. There's often very special kinds of insurance that nurses and caregivers and architects and engineers often have to cover specifically for their profession. Sometimes it's purchased by the company. Sometimes it's purchased by the individual through their industry association and their professional regulatory organization. There's automobile insurance. Of course, we all have automobile insurance. We know that in most provinces in Canada, I think all provinces required by law to have insurance for a vehicle that you own and operate. And of course, companies have insurance as the owner or operator of company vehicles. And so everybody's got a minimum amount of insurance in the event that they cause an accident or they're involved in an accident. And there's different terms, fault and no fault. Is it my fault? Do I pay for you? Is there nobody's fault? My insurance company pays for me. Your insurance company pays for you. But there's also in terms of contracts between a supplier, an agency, and their customer, a requirement that the agency has automobile insurance. And so we refer to this as non-owned automobile insurance because It might be that the employee is driving their own car to deliver something on behalf of the customer. So you got a customer, you got an employee, the employee is driving their car to go to and from two customers' work sites or go to the job site or to deliver something. And you're over here having placed the person into that job, but they're your employee. So an accident occurs, they insure the driver, they sue the driver and say, do you have insurance, driver? And they do, but then they sue the company. The driver's insurance won't cover the company. So the company has what's called non-owned automobile insurance, which means I don't own the car, I don't maintain the car, I don't drive the car, but when one of my employees is driving either their own car or the customer's car, then the agency has got insurance to cover them in case they get sued or found liable also. So we've got non-owned automobile insurance that should be included in every agreement. Of course, there's workers' compensation insurance, which is required by legislation. Some companies are exempt from having workers' compensation insurance. Make sure that you have it because you are the employer of record. And also, in many cases, you can also include independent contractors. So you hire an independent contractor, not an employee, properly designated as an independent contractor to go work for your customer. There are lots of different ways that insurance boards will allow you to include them as if they were employees so that they get covered because they may not, as a small company, as an independent contractor, have workers' compensation for themselves. And then there are terms that we look for in the insurance industry. One is additionally insured. So earlier on, I talked about the company, your company, buys an insurance policy. You become your company, becomes the named insured. But you can say to them, hey, but we always supply services to ABC Company. And ABC Company wants to know that we've got this policy and that it will cover certain third-party events. So you can have your main insurance policy have a clause in it that says ABC Company shall be additionally insured. Now, if ABC Company is additionally named insured, which is almost never, that means that the two companies together have got equal ownership over that insurance policy. So if I had a subsidiary, I might say there's Steve Jones Staffing and Steve Jones Temporary Help Insurance, Temporary Help Agency, and one is a subsidiary company. I could say Steve Jones Staffing Company is the named insured, and I've additionally named Steve Jones Temporary Help, which is different than having a customer covered for some things that we do for them. They would be additionally insured, but not additionally named. So the two named companies are the ones that own the policy and have first right of privilege to it, and so on. And additionally named insured, I'm sorry, additionally insured means that you've extended your policy to cover some stuff that might happen to the customer. So the words additionally insured versus additionally named insured. We've also got the terms joint and several. So joint means two companies, two organizations have got shared responsibility, which could mean shared liability when something goes wrong. And several means that we can separate them and they could be treated independently. And very often we say they're joint and several, which means that we can, this insurance covers us when we're joined, and insurance will cover us when somebody claims in court that they need to separate us, that the insurance will be joint and several. we see things like legislation where, um, under the Employment Standards Act in Ontario, when an agency fails to pay a worker, then there is a joint responsibility. Somebody together has to make sure that they pay, but the government can make them several and say, if the agency's gone bankrupt, we're going to separate them and the customer has a right to pay, has an obligation to pay. So the terms joint and several means that we can join you together, force you to pay. We can separate you and we can force each one of them to pay. And we can force each one of them to pay a bit. That one pays 50%, that one pays 50%. So joint and several. And then indemnifications are basically the promise to indemnify, promise to cover the liabilities that come as a result of the service or contract. So the contract might say, ABC Staffing indemnifies and holds harmless XYZ customer for any harm that may arise or damages that may arise as the result of the services that ABC Staffing causes. So this is the clause in the contract that says my insurance or my company is going to stand behind what we do. And if we cause a problem and you get sued, we are promising to protect you from that. In other words, we will pay. So the contract says we will pay. And then the insurance you buy says it will cover those indemnifications. So there we go. Commercial liability, property, errors and omissions, agency, errors and omissions, contractor, director's liability, those people over there making big decisions, theft and dishonesty, broken down between your employees stealing from you and your employees stealing from your customer, or your contractors stealing from your customer. When they steal from your customer, that's when we use the term bonding, although that's not really anymore the term we use. We call it third-party theft and dishonesty. Professional liability, human rights, contracts, so on. Special insurance, automobile, owned and non-owned. Workers' compensation, do we extend it to contractors? Do we require our contractors to have it? Does our customer require us to have a certification of proof of insurance? And then the terms additionally insured versus additionally named, joint and several, and indemnifications. There you go, insurance. So golden nuggets from today. Let's see what time it is. We're 12 minutes ahead of schedule. It's perfect. So some of the golden nuggets for today, I want you to ask me any questions you want. Before we move on, though, I just want to remind everyone that in the province of Ontario, effective July 1st, 2024, the requirement for employment agencies and temporary help service providers, there is a legal requirement for licensing through the Ministry of Labor. It is two forms of licensing, one for temporary help service providers, one for employment agencies and recruitment companies. It is company insurance, not personal individual insurance. So the company must apply, the recruitment company or the temporary help service provider company must apply. There is a provision for bonding, $25,000, or for an irrevocable line of credit, which means that if there is financial harm caused by breaching a term of the license, that the government can go into your bank account under the irrevocable line of credit, or call your insurance company under the bond and can call on that to pay the damage or the cost or the unpaid wages or whatever. Employment agencies that do not do foreign recruitment and do not do temporary help, in other words, don't have a temporary help payroll, are not required to have the bond. So in other words, the bond is intended to protect foreign workers who come to Canada under the Denny's scenario. And the bond is intended to protect temporary workers who rely upon the financial viability of the temporary help company to pay their payroll. But no bond or irrevocable line of credit. It's two things that are both intended. You can do either or: buy insurance, a bond, go get an irrevocable line of credit, which means the bank writes you a letter and certifies it, says there's enough money here, and no matter what, even if there isn't, we'll make sure you get access to $25,000 if that happens. So irrevocable line of credit from the bank, bond from the insurance company, the end, to be used in the case that a worker is not paid their wages, or that a temporary foreign worker is brought into Canada and something bad happens. They're charged fees for housing or agency fees or something like the Denny story, that the government has a place to go get that money to pay those people. This is unique in the sense that many provinces do not have licensing for temporary help companies. They only have them for employment agencies. It is unique in the sense that it doesn't really differentiate from things like immigration consultants. So if you're an agency and you call yourself an immigration consultant, but you do agency work, you need a license. It is unique that I think I said that it applies to temporary help companies, not just employment agencies. It's unique in Ontario in the event that it existed for 25 or 30 years. Then it was repealed in 2011 because they found it useless and worthless. And they thought that maybe this way, this time, when they write it, they'll do it differently and it'll be more valuable. So they've re-implemented it in 2024. It is unique in the sense that in Ontario, it will cause penalties to be and fines to be put on companies that knowingly do business with a company that's not licensed. So it puts an onus on the buyer as much as the supplier. And there is a long time, it seems, they're slowly getting through thousands of applications. So companies that make their application are approved immediately upon the date of their application. Then it will either be not issued or issued when the assessment is complete, which can take months for it to be complete. Ladies and gentlemen, the staffing services industry has had on and off over the years, depending on who you're talking to, very good and bad reputations. There was a point in time in the 70s and 80s when people thought of employment agencies and recruiters as the third party that did a company's dirty work in order to discriminate on their behalf. That has been put to bed. People now know that we go to employment agencies and executive search firms for some of the most valuable consulting and important information that you could possibly get in running your businesses. They're revered and respected. Temporary help companies have provided a massive benefit to society, to Canadian society, being the that takes a natural resource, human resource, that is abundant and uncontrolled and comes in shapes and sizes and places and amounts and volumes and qualities and skills and experience from all over the country, and somehow efficiently delivers those human resources to the customers that need them when they need them with the best matching and skills they could possibly provide. And yet, while we're helping find access to work and helping companies find access to the resources they need to get the work done, there is still some players that take advantage of vulnerable workers, and there are still some groups and allegations that some temporary staffing companies will do bad things in order to put people to work. And as a result of that, we've got special legislation and employment standards. We've got special licensing now that is required. But the real true answer to this is know your business, know your customers, communicate with everyone, know the laws, become a professional CPC and understand the issues that are confronting you and your customers and your candidates every day. Make the right choices. Not only know what's right, but have the willingness to make the decision to do the right thing. Be proactive, document it, communicate, validate it, make it part of your culture, make everyone aware of it. And as a result of the fact that you are a professional and you know what you're doing and you understand the issues that are there, you're likely to mitigate the possibility that these will happen. And then at the end of the day, protect yourself by having the appropriate insurance and contracts and practices in place so that you know how to deal with them when the situations arise. That's our presentation for today. I'm going to remain on the line for the next 5 or so minutes for anyone that has any questions. So please feel free to demute. And if you